Owen, what could you tell us about what you would change about the law of enforcement?
So I think it's a really interesting question. I mean, we had a big review in the early noughties looking at steps in which we could change the law of enforcement, and there was a lot of feedback, a lot of consultation, and I think to an extent that was an opportunity missed. Whilst there were a number of changes made to the High Court enforcement regime, what we used to call sheriffs, i.e. the bailiffs, to kick in the doors and take the goods. And that has undoubtedly improved that process somewhat. The way that it was done by bolting on some new law to some pretty ancient law has made some rather tricky areas that simply don't make sense, and in unusual cases will cause people difficulty. But what the opportunity I think was missed was to look at a lot of other stuff. Now, whilst the civil procedure rules have now been fully updated, and all the routes of enforcement are now within the civil procedure rules rather than being bolted on from the old rules of the Supreme Court or the county court rules, we still have a number of areas that I think are tricky. So oral examinations, essentially dragging in the debtor or their directors to answer questions about where the assets are and what they are, can be a really useful means of actually finding out what you can get. And even if it doesn't lead to you getting anything, the fact of dragging a director into court can get them to actually wake up and realise they've got to deal with this. But that is a really tricky, tiresome process, because ultimately the sanction for failing to turn up is imprisonment for contempt of court. All the procedural safeguards of contempt of court have been grafted onto the oral exam. So to get someone, then you've got to personally serve the documents on them. You've got to pay them for them to attend, which can be particularly galling when you say to a client that you've got to pay the other side to attend. Not just their travel expenses, but also their loss of earnings, which is particularly tiresome. And ultimately, that can be difficult. And I think that could have been more streamlined and made a lot more simple. I think the idea of personal service in particular, at the very outset, I think just isn't necessary. So that's one area that I would have liked to have seen changed. Where another area that I think has been missed would be a bit of Back to the Future. In many states in the United States, there is a rule that if you have a judgment against you, then you cannot buy and sell property without satisfying that judgment first. Now they have that rule because it's the rule we used to have before they got their independence from us. And I think it's a really good rule. And we got rid of it in the Victorian era. And I really don't understand what the objections are to bringing it back in. We have the situation that obviously one can go and get a charging order over someone's property, but that obviously takes steps and takes cost and expense, judicial time, to achieve post-judgment, whereas there's no reason, as far as I can see, why you couldn't just have a register of judgments, which we already have. And if your name is on the register and the judgment hasn't been paid off, you can't buy and sell property. It would be a relatively simple change to make, and I think it would be a significant improvement.
I'll ask another follow-up question. What do you think needs to take place in order for some of these changes to be considered?
I think the oral exam change is would need a certain amount of judicial laxity, as it were, in the Rules Committee, because ultimately the end game of oral examination is potentially for someone to be committed for contempt. As I say, they think of it as needing all the contempt protections, i.e. personal service. There'd be no issue about whether they can attend, therefore you pay their fees to attend. But the principal goal of an oral exam is not to put someone in prison. the principal goal of an oral exam is to get them to turn up and answer questions. And I think if you shifted the requirements for personal service to later in the process, potentially, and got rid of the requirement to pay for them to attend as a matter of course, I think that would be a helpful process. It would make it more attractive, I think, to many judgment creditors as a route to enforce. To change the law on charging orders would need quite an amount of investment of time. It would need primary legislation and probably some work with the land registry. If one were to strip out the time and cost and effort that's spent in the courts on charging orders, that saving probably would go quite a long way to paying for all of that. But it's, of course, it's always the difficulty that the money we're talking about saving is in the Ministry of Justice, whereas the money we're talking about spending is with the land registry, which is obviously a different branch of government, and that causes issues. But with political will, it can be done.
Okay. That's really interesting to hear. Thank you so much.